The Senzo Meyiwa murder trial started again today from scratch after months of testimony, in-court drama and delays, and then the withdrawal of the judge due to ill health. This has led to a complete restart. Judge Rata Mogoatleng has taken over from Judge Chifiwa Maumela. So let's discuss this now with legal expert Nthabiseng Dubuzana. Nthabiseng, thank you so much for joining us. Why is this happened this way? Because from what I'm hearing, it's extremely unusual for a new judge not to simply read through the court testimony and pick up where the last judge left off.
Actually, it happens more often than not. The main reason that a trial starts de novo and you not reading through the previous attorneys, or rather, I beg your pardon, the previous judges' notes is for you to formulate your own reasons. I think the reason that the presiding officer, the current one, read through the SCA cases in respect to studying the matter de novo was to explain why they are taking the trajectory that they are taking. So in one of the SCA judgments that he read, there was a request, so to speak, between the parties, wherein there was a position wherein they can get the information from the previous hearing and bring it into the new hearing should both parties be amenable to that. So it is not a rare occurrence, at least in my practice in criminal law. I've seen it happen so many times that a judge starts, or a presiding officer starts a matter de novo without wanting to know what happened in the previous matter, so they can formulate their own unbiased opinion. The main reason, if we look at, for example, I want to go back to the case of Nthabiseng, the one where he's being tried for having influenced other judges. So when he was discussing whatever matter with the judges, because he had previously heard that, it was deemed as if he was influencing the outcome of that matter. So amongst others is to avoid the fact that the previous presiding officer may influence the outcome of this matter based on his opinion on what he heard in the matter previously.
All right, so you say it does happen. It has to be, for my understanding, is for a case to continue where it left off with a new judge, there has to be agreement all round. The fact that this case has gone back to step one, does that suggest there simply wasn't an agreement? Or could have, just talk to me about what might have gone into making the decision that was made.
All right, so first of all, there were too many changes in attorneys in the first instance. So there really was no agreement per se with the current defense attorneys and the state. And when we look at the first matter, when it was first heard, there was an application, or rather during cross-examination, Advocate Defo raised the issue of the second docket, which we then found out was never disclosed to the other defense attorneys. So that brought other issues on its own. And then there were situations wherein I think by now there's about 1 or 2 witnesses who have died since this matter has started. So now that changes everything when it comes to the evidence that those witnesses led on the day in question. So when a pre-trial conference was held on this occasion, it was held with every single piece of information or evidence that the state has gathered being present and available to the defense attorneys, unlike the first time. That's why today, when the matter started, after the accused pleaded, then we went to 220 admissions. That was very important, which means that both sides have agreed that we are not going to touch these issues. We're in agreement in this. We're admitting the authenticity of all of this. And then we're only going to focus on the issues which are in dispute, being the elements of each crime that is being faced by the accused, which is intention of each crime, unlawfulness, the act itself, and the other competent verdicts that could follow as a result of having been found guilty. So already as it is, the issues have been narrowed down significantly, unlike the first time wherein, remember, there were issues about, but the can wasn't placed here, it was placed there, and therefore the photographs that were taken were not authentic. So those things are not going to be canvassed anymore. They've been dealt with, they've been admitted. We're only focusing on whether or not the accused persons before the court were indeed the perpetrators on the day in question.
Okay, so now there's a lot of stuff that caused delays has now been sorted out. So this may, although it's a total do-over, it may continue apace. And certainly what our senior reporter was saying to me earlier is that this new judge seems very direct, very focused indeed. Just talk to me about why the state changed its order of witnesses, because it started with, I think, the forensic investigator, Beloy, if I'm not mistaken, first time round. This time, straight to Zandi Khumalo, who was in the house on the night that Senzo Meyiwa died. Does that indicate a change of strategy, perhaps, on the part of the state?
Yes, indeed. Like I was saying, the 220 admissions. Okay, maybe perhaps.
Maybe explain that to me. Yeah.
220 admissions are. Yes. So, in terms of Section 220 of the Criminal Procedure Act, it's wherein you admit certain facts pertaining to the case itself. So, in that essence, it's like, for lack of a better term, it's like a guilty plea of sorts, wherein you're accepting that this is the situation. I'm not going to dispute it. It is what it is. So it's an admission put down in writing that you take this as this evidence to be true and correct, and you will not question it. So it kind of, the court doesn't have to deal with that. That's why it has to be reduced in writing. And when it's done that, the court has to converse with the accused person and confirm that, are you sure that you want to admit this part of the evidence? You don't want to challenge this. And if the accused confirms through their legal representative as well, then those things are dealt with. So part of the 220 admissions today had to deal with part of the forensic findings. So they're not going to touch that at all.
Okay. So they're not, just to be clear,
no need to call.
So they're not going to go back to all the witnesses we've heard, is that right?
Yes.
So some of it is being carried over?
Yes, from what I can see.
Okay. Okay, that's very interesting. So it is a start, but it's not a complete fresh start.
Yes, it's not a complete fresh start. It's just trying to narrow down the issues. I really believe that in the first trial, there were, the parties were not coming together. I mean, you could see it in any event when the matter was going ahead, how, for example, Advocate Diffo would stand up and interject in the inappropriate times, which means the procedure had to be explained to him over and over again. But in this instance, it seems like all the defense attorneys are of the understanding on how criminal procedure must be followed. And therefore, it makes it easier for this thing to flow. So if you understand the process you're supposed to follow, then you can come together as parties and narrow things down, and you just do what is necessary. So, yeah, we're hoping for the best. It looks like it's going to be better going forward.
So we're not going to perhaps rehear every bit of testimony, but certainly when it comes to, for example, Zandi Khumalo, we are hearing her again. She is saying pretty much what we heard last time at this point. Obviously, it continues tomorrow. And that leads me to my next concern. Surely it's going to be very difficult to not think about what someone like Zandi Khumalo said the first time she testified, and then perhaps for the defense to use it to trip her up. I mean, this was televised. Everyone's got access to her audio. Isn't that prejudicial in a way?
Unfortunately, it is. I think this is one of my pet peeves when it comes to this matter. I wish it wasn't televised. I wish it wasn't, the audio recordings were not out there, because in a normal situation, when a criminal matter is being heard, the witnesses are not privy to what is being said by the people testifying before them, right? The main purpose of that is that when the second witness, who is either implicated by Nthabiseng, who was testifying before, and then Sandy now comes in to give evidence on the same issue, whatever Nthabiseng said about Sandy, I can now use it against Sandy if Sandy contradicts what Nthabiseng said. That's the reason why witnesses are not permitted to be in the courtroom to hear what the other witnesses say, because now they can prepare their story and make sure it is aligned. Whereas when you don't know what the other person is saying, then you come there with your own version, and based on that, either it is going to corroborate your fellow witness, or it's going to contradict it. Now, looking at what happened in the previous case in its entirety, a lot of things happened there. So what the defense can do is try very hard to block out everything that happened. But I think the advantage of that is that whatever she is going, or any witness rather, is going to say going forward, is that they can make a side note of what was said in the past and see if under cross-examination they can bring up that situation, but without referring it to what was said in the previous case.
The other issue is cost, because costs have to be paid again. It's people's time and money. Slee was explaining to me that even the private legal representatives for some of the defence attorneys, they are now applying for legal aid to pay their costs. So everyone, you know, the cost to us, the taxpayer, surely has increased massively with this decision. Am I right?
Yes, that's very true. For starting the matter from scratch again, obviously costs are going to now double or quadruple depending on how it was. So at this stage, if legal aid is taking over the matter, it means it's doing it through what we call judicare, and judicare has to be approved. But then I don't know if I should say the good part about it is that judicare tariffs are not as high as a normal tariff. So counsel appearing in the High Court, junior counsel usually would charge somewhere around 17,000 per day, or 20,000. And then senior counsel can go as high as up to about 50K per day. So if we're dealing with legal aid taking over in terms of judicare, they have a scale wherein they cap the fees of the attorneys and counsel, and there's forms you need to fill in wherein you confirm that you appeared on this day. So it is kind of monitored in that way, but it doesn't take away from the fact that the costs, unfortunately, keep going higher as a result.
And a final question, just your assessment. Do you think that this decision to basically have a do-over of this trial is going to deliver justice for Senzo? Do you think it was the right decision to make?
I think so. In looking at how this matter started for me, that one was like, okay, at least there's a way forward. And in the beginning, Sandy, there were too many applications within the main matter. We were not really dealing with the merits of the case. We were dealing with other interlocutory applications which ought to have been dealt with in pre-trial conference. They should not have made their way into the main trial. But the way that it has started now, a lot of things have been dealt away with. I don't think it will take as long as it was foreseen in the beginning, that it might take another year to finalize this matter. I think we are looking, if the witnesses, if, for example, there were 8 in the first matter, they've cut out about 3 or 4 by admitting certain things today. So there's about 4 people left. And then we're just going to deal with those. And then, of course, the accused persons themselves taking the dock. We might have a verdict, or at least the evidence would have been dealt with and led by the time this year ends. And then maybe next year we'll get judgment. So I think that it's a good thing.
Thank you so much for your time. Really appreciate it. Legal expert Nthabiseng Dubuzana there.